Today's topic is going to be about pre-charge cases or investigation stage cases. Now, the term pre-charge or investigation stage case means you have not been charged with a crime yet, but detectives want to contact you or somebody's made an allegation and you need some help. Why is it important to get a lawyer at that stage? Well, if you were charged with a crime and 5 minutes later they dismiss it, it's different than if you were never charged. For example, on an application, it'll say, have you ever been charged with a crime? And if you say, yeah, but it was for child molestation, it was a false allegation by my spouse, it was dismissed 5 minutes later, it was all a big misunderstanding. Well, they're going to throw your resume in the garbage can. Or if they do a criminal history check and see that you were once charged or arrested for a sex offense or any type of felony, a lot of times you're out of the running for a job. So you need to hire a lawyer now so you don't get charged. What will we do? Well, I'll give you a standard case. Somebody comes to us and says, oh my gosh, I was in a bad accident. They might charge me with vehicular homicide, or my spouse is accusing me of molesting our kids because we're in a custody battle. Well, there's a couple things we can do. We can contact a detective, a private detective that we will put on your case. They can go out and do research on the alleged victim, whether it's a car accident case to find out if that person has prior DUIs, drug problems, drinking, road rage issues, or against a former girlfriend or ex-spouse, finding out what they have in their past, showing that they're untruthful, maybe been convicted of shoplifting, something that would show that they're not honest. They can also pull up former divorce paperwork, not only on your ex-spouse, but you'd be amazed what they can find out about a so-called victim, even on a driving case. They can find out, wait a second, this guy's ex-spouse accused him of drinking all the time, being violent, driving like a maniac. You'll be amazed what they can find. We can do a polygraph. Our polygrapher will do a lie detector test, and we will sit you down with them and they can ask, have you ever touched so-and-so for a sexual purpose? You pass that, we can bring it to the detective and say, look, this is not credible what this person's ex-spouse is saying. We can do a risk assessment or a psychosexual risk evaluation to show through testing that you are not a pedophile, that you don't have these tendencies, that this person is making this up about you for custody purposes. We can do an accident reconstruction to show you weren't going as fast as they say you were going if it's a car accident case. We can do drug testing to show that you are not on drugs and that the person accusing you is lying, or if drugs were found in a common residence with roommates who share the room, they're not yours, because if you had them, you would probably use them, and here's a drug test showing that you're not on drugs. We can do an independent medical exam. For example, if you're accused of molesting your own kids in a custody battle, we can send them to a doctor and have them independently examined. And if there's no proof of any physical, anything physical, we can show that to the detective. Lastly, we will contact the detective. We will say, we represent you. Do not contact this person. Talk to us. We will put something together and sit down with you in the near future. And at that time, we can bring independent medical exam, polygraph results, private investigator results, psychosexual risk evaluation if necessary, accident reconstruction, drug testing results. We can do it all. Lastly, we will file what's known as a Trebus letter. Trebus versus Davis is a case that says if we provide a letter to the prosecutor, which includes exculpatory evidence and a request that you want to give a statement to the grand jury, they have to tell the grand jury that you've requested to make a statement. Now, the grand jury can say we don't want to hear from them, but they also have to say, and by the way, here's all this exculpatory evidence that Mr. So-and-so has provided. Now, they're not allowed to say through his attorney, because they'll be commenting on your right to counsel, but they can say, here is this evidence. And you'll be amazed how many times grand jurors will look at the evidence and decide, we're not going to issue a true bill. We're not going to indict this individual. So, that being said, if you are in the pre-charge phase or case investigation phase, you need to hire a lawyer and shoot down the allegations as quickly as possible. One parting note, if the case involves a sex offense or a dangerous crime against children and you're charged, you're non-bondable. That means even if you have $1 million in your pocket, you're not entitled to bond. You will sit there in custody until the case is finalized. Now, there are some motions we can file to try and show proof is not evident, presumption is not great, but you'll end up sitting for 4 or 5 weeks before we can get you out. So you don't want to be charged. You want to attack it up front. No matter how preposterous the allegations are, You need to attack them now.